Should I start?
Hello, good evening to all participants, our speaker and dignitaries of CIADR. My name is Hiranshi Shah and I'm the moderator of this webinar. I am the Secretary of Gujarat branch and also the International Mediator and Associate Member of Charter Institute Arbitrator, United Kingdom. The CIATR is the online dispute resolution center which provides very reliable and cost efficient dispute resolution service since 2018 in all over the world. It's now renowned for its fast written dispute resolution and very experienced independent arbitrators and mediators in South Asia. CIADR is also aspired to an interpret provider of the premium institutional aid as a tangible and independent venue for conduct the domestic and international ADR and ODR service. I welcome you all on behalf of the Center for International Alternative Dispute Resolution in this webinar on pros and cons of the arbitrator. Before starting the webinar, I will introduce our guest of the today's webinar, Mr. Yogesh Rawani sir. The speaker is a practicing advocate of Gujarat High Court since 1993. He has a work as a central government counsel from 1997 to 1999 and later on from 2004 to 2010 at the High Court of Gujarat. He was also senior standing counsel for Central Excise Custom and Service Tax Department. He has a wide experience of civil cases and also the arbitration and admiral proceeding. I welcome you, sir. Before we would start, I would like to request the all participants to kindly mute yourself. If you have any question, you can write it in chat box so we can take it in last 10 minutes. Sir, now this floor is all yours. Thank
Please.
you, guys.
Thanks. Thanks for giving me an opportunity to speak about the arbitration and the pros and cons of the arbitration proceedings. So far as arbitration proceeding is concerned, when there is civilized society, there are always dispute arises from commercial transaction, from contracts, from social life, and each civilized society has made attempt to find out the mechanism for resolution of disputes. In old monarch time, we were having system of panchas. Later on, after British rules, there are common laws countries where we are following rule of law. There are other countries where French system is adopted. After development of international business, the local judicial system was not found sufficient for proceeding with the international disputes. The requirement was found by legal expert to find out some other mechanism which can expedite the proceeding, which can solve the international disputes of the international parties, as well as domestic issues also, where the court proceeding may take some longer time. Now, in view of this background, arbitration proceedings, which is alternative dispute resolution, is one of the most accepted formula. And there is consistent increase of the arbitration proceedings. Invariably, in many of the contracts of international transaction or business, we find arbitration clause for resolution of the disputes. This dispute resolution mechanism is concerned. India has also accepted UNCITRAL model rules based new enactment, that is Arbitration and Conciliation Act 1996. After this enactment, previous Arbitration Act 1940, the Foreign Enforcement and Acceptability Act 1937, and foreign awards recognition on enforcement acts were repealed because all three laws were covered by new act of 1996. Now, so far as arbitration acts are concerned, India has enacted its law based on the UNCITRAL model, which was internationally accepted model. In spite of that, number of defects were found while applying law in practice. Therefore, to freeze out such defects, India has enacted further or made amendments in law of Arbitration Act 1996 twice. Firstly in 2015 and later on in 2019, and tried to freeze out certain defects. Now, many of the defects are removed. Still, there are certain aspects where it is gray area. Certain countries have not amended their laws accordingly. Therefore, when there are international agreement, certain issues definitely arise, which are having conflict of law. The disputes do not get correctly resolved because of the defects in the law. Today I am having a topic about what are the pros and cons of arbitration proceedings. Arbitration
Yes,
proceedings.
today is like different. Like everyone's will talk about only the pros, and like we are believe that ADR is now growing fastly. So like yeah, so today the participants will also know there are some cons also. That's why like why it's not. It is a like one method of ADR, but people are not like as to not adopt as to legislative process.
No, that's a defect also. I will tell what are the defects, what can be removed, and being a legal person, when arbitration proceedings are concerned, sometimes contract is to be drafted by us. At the time of drafting contract, what kind of arbitration clause should have been incorporated, or what kind of precaution is required to be taken, that also I will tell. Because the arbitration clause sometimes worded which is defective in language, and therefore there are certain complications. We all know that advantages of choice of arbitration law is because the parties are having opportunity to select their own person who will decide their dispute. Therefore, person of field of expert can be also appointed as arbitrator. Like chartered accountant can be appointed, company secretary can be appointed. This is advantage. There is complete relaxation about time, place, and so far as venue is concerned, there are complete relaxation in arbitration proceeding. Court is concerned, there are no such relaxation. We can't decide that we'll start our arbitration our court proceeding at 5 o'clock. But in arbitration, we can decide that we'll do it 5 o'clock. We can tell that we'll proceed day to day. That can be possible. Court is concerned, we have to adjust time with them. Therefore, there is second advantage is time and place. First is expert person. Third is, so far as we arbitration is concerned, it is not fixed by fixed procedural law. It is not having tight procedural law like Evidence Act and other procedures. They are broadly required to be applied, and not something like which is traditional Indian courts are applying or any other domestic courts are applying in world. These are basically well-known advantage of the arbitration proceedings. So far as disadvantage are concerned, certain disadvantages are there. Firstly, domestic courts are run by normally backed by the domestic governments or the local governments. Payment of postage stamp may be there, but in comparison of arbitration proceeding, that fee is quite less. So one of the disadvantageous situation comes for the arbitration aspect is about the fees which party has to bear for the entire judicial proceeding. Now, there the government can do certain things by establishing the arbitration centers, which Indian government is trying to initiate by latest amendment in law, and they have also enacted Delhi Arbitration House Act. It is in 2019. It has been done. So there will be certain cost cutting because today arbitration proceeding goes on at private places, something like some PSU office, hotels, or the place of the certain halls where the arbitration proceedings carries on, where the private arbitrators are charging them according to their requirements, standards of fees. This is something affordable in arbitration or the dispute which is having high stake, but maybe slightly costly for the small disputes, which will be affordable in the court proceeding only to get resolved. Now, so far as the second aspect is concerned, the arbitration proceedings are concerned with a view to get expedite disposal. These proceedings are concerned, the challenging method is limited. Like in India, arbitration award can be challenged under Section 34 of Arbitration Act 1996 before the district court. Now, that district court is concerned, it has limited aspects to be seen. Very limited aspect about the validity of appointment of arbitrator, about the jurisdictional error or patent error only. Now, this was concerned, the our Indian court had taken a view, very famous decision, which is known as Sow Pipe. It was case ONGC versus Sow Pipe, but the ONGC is common litigant, therefore well-known judgment as Sow Pipe, wherein Supreme Court tells that law which is opposed to the public policy of India should be treated that absolutely pervert judgment or patent error of law can be treated as jurisdiction or it is opposed to the public policy of India. That way it had widened the scope. However, still there are very limited scopes of appeal decision in the arbitration proceeding. No doubt, this may bring the decision quicker, but certain time or in certain cases, when there is a defective decision of arbitrator, it seems that hands of the appellate court gets tied. In civil proceeding, in civil court, when there is a decision, first appeal court will entirely consider the decision thoroughly, and after that it will be decided. Then there will be second appeal, and then there will be Supreme Court one can approach. So there is three time it has been verified, and then it is finality. So far as arbitration proceeding is concerned, under Section 34 limited scope, under Section 37 it can be challenged before High Court, where also very limited scope, and then before Supreme Court there is obviously limited scope. Only in this process also, suggestion can be there that there should have been further appellate forum of the arbitrator themselves, like single judge arbitrator, single arbitrator decision can be considered by way of appeal before the division, two judge, two member arbitrator or three member arbitrator, and can be verified. So there can be opportunity of complete scrutiny of arbitration award. Now, these are aspects which is defect in the arbitration proceeding. Now, so far as arbitration proceeding is concerned, the main object was to get it expeditious disposal. Therefore, recently in 2015 amendment, section 29A, capital A is added by the uh, Parliament in Arbitration Act 1996. 29A prescribes 12-month time for completion of arbitration, and with further permission of the court and with consent of parties, further 6-month time can be added. That is 18th month time. After 18 months of time, if the arbitration award is not given, then the court tells that law provides that arbitration mandate gets over. Now, there is a further blackout or gray area. If the after 18 months, if the arbitration proceeding is concerned, mandates get over. Some advantageous party will tell that now arbitration cannot go ahead because they had to pay money or they had to comply some contract condition or something. They would happily tell that now arbitration mandate is over. Now, law does not provide that what would be the further situation or further procedure to be followed. Therefore, there is a gray area in 29A that after mandate gets over or terminated of the arbitrator, what is to be done? There is nothing to be shown. Now, after that, suppose in 18 month award is there, then in that situation, further aspect comes when we are talking about the expeditious disposal, section 34 proceeding. 34 proceeding under section 34, the award is required to be challenged before the district court. Subsection 6 speaks that it should have been uh, within 1 year completed by the district court. It is my personal experience that in district court, first date of hearing against the award decision is given after 6 months or 8 months, and not a single matter gets heard within 1 year period. So, district court and then High Court and Supreme Court, the proceeding goes on for number of years. There is in 37 when the first appeal comes before the High Court, there is no limitation prescribed that within how much period it should have been completed. Then before Supreme Court also there is no period is prescribed. In that eventuality, the proceedings of arbitration goes from arbitrator to the district court, then high court, that it is again going to judicial forum. And once it goes to judicial forum, again it becomes a procedure or part of the procedure of Indian judicial system or any judicial system of world. And then again it gets stuck up. Then the entire purpose of expeditious disposal does not get subsolved. In this view of the matter, the purpose of arbitration of expeditious disposal is concerned does not serve.
So
Suggestion on
this
my
is like sir main drawback of this, like time efficiency. The litigation is not like
yes, it is increasing and therefore ultimately in district court and everywhere it is yes, no doubt civil court takes quite longer time. In comparison of that, arbitration proceedings is quite quicker within 1 year or maximum by 1.5 year. What 8 to 10 years normal civil court takes place gets completed. That is true. There cannot be dispute on it, but it should have been again get separated so far as appeal proceeding is concerned from judiciary and should have been given to independent arbitrator tribunal itself. Like many of the tribunals, we are having separate appellate forum like NCLT is recent creation in India, national uh, uh, there's a company tribunals. Now against that NCLT is there, DRT is concerned, debt recovery tribunal, debt recovery appellate tribunal is there. It is no separate from the high courts and supreme courts and other things. So that can be done by separate forum, and that can reduce the time period, and the purpose or object of the arbitration expeditious disposal can be achieved. Now so far as one of the major defect of arbitration is that in India arbitration is absolutely everywhere in world, arbitration is absolutely in personam proceeding. Two parties which are in agreement would have got arbitration proceeding between them. Now that decision is concerned, no doubt it will bind to those two parties only, like a contract, breach of contract or anything, then it will be binding to those parties only. But many of such decisions of the parties inter se would affect third parties. Like it is a contract matter, the contractor lose or succeed, ultimately it affects subcontractors. If the amount is declared as not recoverable, then tax department, income tax department will be affected, or other department GST would be affected. Now these third parties who are getting affected are not having any right to appear before the arbitrator, nor they are having opportunity to challenge it, because these proceedings are in personam. After 3 or 4 months, arbitrator would not be keeping the records available with them. They are giving back the records to the parties concerned litigating. So there would not have been any forum like civil court from where we can get the copy of the record and we can challenge it, any of the judgment or decree of civil court before the high court with leave of the appeal under section 96, or before district court if it is a smaller amount of the value. Therefore third party is not having opportunity to get record, get challenge it, though it may be affected by such arbitration award. There may be some collusive awards also which requires to be challenged by third party, but the opportunity does not get, and therefore sometime they will have to go before civil court, where it is absolutely doubtful that civil court is having any jurisdiction to declare that award is not binding to them, or they cannot be applied to them or anything. Therefore the uh, aspect, the requirement in India is that there should have been house, the arbitrators who are conducting arbitration must decide the disputes having numbered it, and such records should have been preserved for certain years. It may be digital maintaining of record or physical maintaining of record, should be made available at the request of even third parties, and such third parties should have get some opportunity to challenge it before the appropriate forum. Now this is a lacuna in the present arbitration act. Now, this can be creased out, this can be removed by legislation. Yet, nobody has addressed on this aspect. And these are the aspects about the not having the procedure for expeditious disposal of appeal, rights of the third parties to challenge it, alternative appellate forum of the arbitration. These are the say, other aspect of the arbitration which we are going to challenge, which we are going to contest in the arbitration proceeding, and then we will face these aspects. Now, one more aspect which is also absolutely relevant for our purpose, that so far as India is concerned, It has no house like Maritime Arbitration Tribunal of London or other things. The arbitration proceedings here goes on at private places. Proceedings are not in public. Now this is for purpose of maintaining confidentiality in certain commercial disputes. Simultaneously, record maintenance are not there. Therefore, a forum should have been created wherein the arbitrator wishes there should be some authenticate forum who maintain this record digitally, and on request such record may be made available to any of the parties on certain charges also. If this is not done, the there are all likelihood of having certain problems of authenticity of records and other things. Now, one of the vital aspect, this has occurred after decision of Bharat Heavy Chemicals, the Bharat Aluminium Corporation in 2012, which has overruled two decisions of Supreme Court, Bhatia International, and other decision was Navkar Limited. Now, these two decisions are concerned. In case of international arbitration also, our court had taken a view in Bhatia International that Indian courts are having jurisdiction for exercising power under Section 9 for grant of interim relief. We all know that any court which has no power of granting interim relief is a tiger without teeth. If the subject matter of the dispute is not maintained, there are always all chance that when the decree is passed, it becomes a paper decree. The subject matter may not be preserved. There may not be money available to be recovered by the decree holder. Therefore, power of interim relief is vital for any of the judicial proceeding. In absence of such power, ultimately nothing can be achieved for many of the parties who may be successful in the proceeding in proving their case. So far as our Supreme Court had taken a view that there is lacuna in law, and therefore interim relief is concerned in international arbitration, Indian courts have no jurisdiction. To overcome such situation, our parliament had amended section 2 of the Arbitration Act 1996, and they had changed the definition of section code, as well as they have made amendment, and they have added that the provisions of section 9, section 27 B1 and section 37(3) would get applicable to the international arbitration also, which had empowered local courts or the high courts to grant interim leave in case of international arbitration also. No doubt, till the amendment took place in 2015, there was a gap, and there was dispute about it. However, now situation is clear that Indian courts are concerned, domestic arbitration are concerned, district court, that is principal civil court of India, are having jurisdiction to grant relief under section 9. And in case of international arbitration under section 9, high courts are court for the purpose of grant of or exercise of power under section 9. So far as one more gray area is, which is by recent decision Supreme Court has cleared so far as India is concerned. Once the international arbitration is concerned, in international arbitration, what would be the jurisdiction of appellate court was not certain. Because give an example. Suppose an Italian company which is owner of a ship may sell to a Dubai person a ship who ultimately sell it for the shipbreaking purpose at Bhavnagar Alang, or Indian owner for shipbreaking purpose, and dispute arise. Suppose in that case the clause provides that in case of arising of dispute between the parties, Maritime Tribunal, London, Arbitration Tribunal, London would resolve the dispute. Then the seat and venue would be the London court or the London Arbitration Tribunal. So far as owner is concerned, is from Italy. Then here cash buyer was Dubai. Last purchaser was at India. Now ship which is lying at India, therefore cause of action had arisen at India. The subject matter is at India, but the arbitration would be there at England. Now, once the award pass, question arises that which court will have jurisdiction to be challenged, whether British court will have jurisdiction to decide about the challenge against the arbitration award, Indian court will have jurisdiction to get it challenged, or Dubai or Italy. Now, there are two views there are on this aspect. One view is territorial views. Territorial view is very clear that seat of the arbitrator is concerned will have is concerned, it decides the jurisdiction of court, and therefore once the London is the place of the arbitration or seat of the arbitration, it will have jurisdiction to decide the dispute between the parties. So far as other view is delocalized view. Delocalized view tells that the place of the seat or venue of arbitration is irrelevant, because there merely arbitrator sits and decides the dispute. But once that dispute is resolved, it is an international arbitration award. It is not the award of British arbitrator. It is not the award of any particular country. It was only a seat or the place of venue, and therefore the British court is not having jurisdiction. Then, in that situation, so far as India is concerned, India has not accepted delocalized view. And recently, in a decision of 2024 SCC, someone wants to note it, they may note it, 2020 volume 4 SCC page 234. In the case of BGS, SGS Soma versus NHPC, Supreme Court has taken a view that so far as seat of the arbitration is concerned, agreed by the parties in their agreement, would govern the jurisdiction so far as court is concerned. And therefore, British court, where the arbitration proceeding goes on, then the British court will have jurisdiction. If it goes in some other country, then it is indicative that that country court will have jurisdiction. Therefore, India is concerned, it has already resolved the issue that so far as award is concerned, it can be challenged before the court where the seat of the arbitrator was there. If the one more aspect, that the so far as seat of the arbitrator is concerned, if the arbitration agreement provides that the procedural law of that country would be applicable, then it would be more indicative of the aspect that that law is to be applied and therefore that court will have jurisdiction. Supreme Court tells that in that decision further that the so far as there is no clarity about the seat, then so far as Section 9 is concerned, for interim leave, even if it is international arbitration, then the number of court will have jurisdiction where part of the cause of action has arisen or cause of action has arisen or defendant resides, wherever the uh, cause of action has arisen, one can go. So far as other delocalized view are concerned, certain country believes that such international arbitrations are concerned. This arbitration are concerned, the seat of the arbitration has nothing to do with the appellate jurisdiction of that country or the appellate court powers of that country. Because so far as UNCITRAL law is concerned, a New York Convention is concerned, it speaks that any arbitration award which goes for enforcement, that is for execution, for that purpose, that court may accept that for enforcement. Therefore, the court which is applied for enforcement will decide legality and validity thereof. Therefore, similar this issue had arisen, which is decision is 2013 3 Wells Law Reporter, page 1329, wherein it was party's name was UCOS Capital, Y YUKOS Capital SARL, UCOS Capital SARL, wherein the similar situation had arisen. The arbitration tribunal in Russia rendered four awards. Then, so far as these awards were concerned, arbitration tribunal court was approached. In such proceeding, Russian judgments were concerned. They were challenged and set aside by the Russian court. Now, this was challenged before Netherlands. That was parties approach Netherlands court for enforcement thereof. Netherlands court refused to recognize the order of the Russian courts, telling that this would not be a correct approach. It would be considered by the Netherlands enforcing court, and they refused to consider this aspect. Therefore, similar issues had arisen again in many of the countries, and the ultimately it was view frequently changed. Now, with this background, since many of the participants are from low background, I would suggest that when we are drafting the arbitration agreement between the parties, we must keep in mind both the views prevailing in the world. One is about territorial jurisdiction, territorial view, or and other is delocalized view. Therefore, the parties which are approaching with us having international background, international transaction, we must consider the local laws of those countries. We must keep in mind about the appellate jurisdiction as well as the jurisdiction of interim relief. Recently, in one decision of our Supreme Court, the similar issue had arisen. So the one of the clause was telling that for the purpose of dispute between the parties, Indian court at Delhi will have jurisdiction. And same way, other clause was there of arbitration, of international arbitration to be carried on at London. In that background, the interpretation was required to be done by Honorable Supreme Court. Supreme Court tells that so far as Indian court jurisdiction is concerned, party's intention is to see that for interim leave, party can approach the Indian court. And so far as arbitration main proceeding is concerned, the jurisdiction would be with International Arbitration Tribunal, which has been prescribed by the parties. So when we are drafting any of the arbitration clause in the contract for the clients, we must bear in mind the two views prevailing in the world when we are drafting. So far as India is concerned, we have to keep in mind the latest decision of Supreme Court in 2024 SCC page 234, which I had given, that it tells that now, so far as jurisdiction is concerned, it will be jurisdiction as stated therein. So far as country which is following the system of territorial view, where the seat of the arbitration is concerned, will have the right of going to between the parties. Right will be there to go to the same court of that country is required to be considered from that angle. If that is not there, we have to specify that the right of the appeal between the parties against arbitration would be of the country concerned to avoid any complication. Otherwise, there are likelihood of complications thereof. So, in my view, arbitration method, as we know, is increasing its momentum. Now, at that stage, we should keep it in mind that the there are certain defects still prevailing. To avoid the difficulties, we have to be careful in drafting our arbitration agreements. So far as arbitration law is concerned, it is going to expand the one more new amendment which has been done in 2019 about the qualification of arbitrator by adding new schedule by Indian Arbitration Act in the Indian Arbitration Act by Indian Parliament, which avoids repeated arbitrator for the same purpose, so that institutional favoritism can be avoided, because certain companies permanently appoint a person as arbitrator in all the dispute. On other side parties gets changed, so arbitrator would be lean to decide in favor of the company which is frequently engaging them as arbitrator. Otherwise they would be removed. Therefore, to avoid such situation, now amendment is done that the repeated arbitrator cannot be appointed by the parties. So while drafting arbitration clause and appointing arbitrator, we must keep in mind that now section 12 and schedule thereof is amended to an effect that person cannot be arbitrator frequently for a party in different disputes. So if the uh, more care is taken at a stage in the drafting of the arbitration clause, the better result can be achieved, and the arbitration award or concern may get finality and may not be stuck in the different kind of technicalities. Therefore, this was the topic. I hope the detail would be interesting for all the participants. If there is anything, I would be able to give my any other aspects. I will be happy. Thank you
Yeah.
for hearing me peacefully.
Thank you so much for your wonderful webinar, sir. This is a like very knowledgeful webinar, as to like you stated many Supreme Court judgments also include the international aspect, and also like provide us brief idea of the Arbitration Act in India. So, sir, I would like to ask the first question. As to you have stated that if the third party have an interest in arbitration, so they are not like a challenge, as we in courts we can if any third party have an interest, so they will get documents from the court. So in arbitration there is a no any maintenance, the data is maintained by anywhere. So yeah, it's very good suggestions from your side, sir, that would be maintained. But sir, in case the third party would have an interest, so can the third party join the arbitration proceeding if
Uh,
he have a interest in that case?
uh, the law provides that there is no provision for joining party. Like in civil procedure code, we have a provision of Order 1 Rule 10 of joining party application. The interested party can make application for joining party and can be joined in the proceeding where they are affected. So far as Section 96 are concerned of CPC, the Supreme Court has taken a view that the party which are affected can prefer appeal, though they may not be plaintiff or defendant in civil court, but they can prefer appeal if the decision of the civil courts get affected them. So far as arbitration is concerned, the provision of law is that the arbitrator award required to be challenged within 3 months, and 1 month more can be delay condonation can be done. That for 120 days is the outer limit. Now, so far as arbitrator is concerned, he is a private arbitrator. He is not something like a judicial forum, so he would not be maintaining record for longer time. Suppose a third party comes to know after 6 months or 8 months or a year, and about the award, he sent a copy of the award. Like tax department is sent the award that this is award, this money is waived off, and therefore I am not liable for tax. And for them there is no option. If they go to arbitrator, they will tell that I have destroyed record because now after 4 months there is no appeal. Therefore, I have not kept it. Private party will not supply anything else than the award copy of the award. Therefore, only option can be available to the parties, third party, to file a civil suit telling that this award is not binding to them. Like a subcontractor is there, contractor lose in the arbitration proceeding, but maybe collusively they might have lost with the principal. But subcontractor wants to challenge that this is a collusive order, and he has no right to challenge it before any of the forum. Nor they have right to means go before the arbitrator because they are not party in the proceeding. So this is a type of situation which I had seen arising in certain proceedings, but there is a certain lacuna thereof.
Yeah, so Indian parliament must look out this thing as to amend, so we can better way of the act.
Yes,
Thank you so
that's true.
much, audience. You have any questions, so you can write it in chat box. So otherwise, we can wrap up this webinar.
If anyone is having any question, they can certainly send it to me directly on my email address also. My email address is ravaniyogesh@yahoo.com, or even they can approach me directly on my mobile number. My mobile number is 9824049791. Thank you.
Yeah. Thank you, audience. Thank you, sir. Thank you.
Thank you.
Thank you.